So the legal grounds for divorce in Illinois are irreconcilable differences. That's the only option you have. But irreconcilable differences essentially means one person wants out of the marriage. They feel like there's nothing else that can be done to save the marriage. So Illinois is a no-fault divorce state. This means that you don't have to prove fault. You don't have to prove somebody did something wrong or who did what. It just means I want out, and that's why we have irreconcilable differences. There is no effect on filing. The residency requirements in Illinois for divorce it's a 90-day period. So you have to be in Illinois for 90 days prior to the filing of your petition for dissolution of marriage, or 90 days before the judgment becomes final. This means that if you live in Illinois 90 days before you file, you're good to go. If you lived outside of Illinois, you have to live in Illinois for at least 90 days before your case becomes final. So in Illinois, you're going to file in the county in which one of the parties resides. Typically, it's going to be in the county where the kids reside. So that's where you're going to file your case in the Domestic Relations Division. So a major difference between a contested divorce and an uncontested divorce is whether the parties agree or not. So most people start off with a contested divorce and end up with uncontested, meaning they start off with not everything agreed upon, but eventually you're going to get there. And once you have everything agreed upon, it's considered uncontested. So a joint simplified divorce applies for very, very rare circumstances. Most people do not qualify. However, if you make under a certain amount of income, have less than, you have no children, don't own any property, and your retirement accounts are under a certain threshold, you may qualify for a joint simplified divorce. So I would say there's no typical divorce in the sense that your case is going to be different than anybody else. Depending upon the issues, it could be anywhere from 6 months to 2 years, but the average probably about 12 to 18 months. So to get a divorce started, you got to file a petition for dissolution of marriage. That's a document that actually gets things going. Then you've got to get the other side legally involved in the case. So if they want to do that voluntarily, they can file a document called an appearance. If they don't want to do it voluntarily, you're going to have to get a summons and then get notice to get them served with the papers. So once divorce papers are filed and they've now been served on the other side will have 30 days to file a response, and they can also file a counter petition, which means that they can put forth their allegations. Once everyone's officially involved in the case, you're going to move into discovery and temporary motions.